think this is wrong. Gotta pay him. Miss Smith and Miss Tweed.
Good afternoon.
Good afternoon.
What you need? It's okay. It's okay. It's okay. Are you guys ready?
Yes, we're ready.
Friday, the 4th of December, 2020, Commercial Court 2 via Zoom at 2:39 before the Honorable Justice Sabir Williams, Appellate Jurisdiction 2020, number 18, Fiona Miller, Police Sergeant versus Shayne James, Ms. Smith and Ms. Tweed for the appellant, Ms. Christopher for the respondent.
Yes, good afternoon, everyone.
Good afternoon, my lady.
Do we have Mr. Shayne James appearing? Because the label is Bermuda, and I think that's an error.
Yes, he's here in this area, right in front of you now.
Thank you very much.
Yeah.
Sir, you are Mr. Shayne James?
Yes.
Okay, thank you. And this is the Crown's appeal against the decision of Magistrate Tukumbo in respect of a no case ruling. I see I have Ms. Kentisha Tweed for the Crown. Will you be presenting the appeal?
Yes, my lady.
Okay. All right, well, let's start.
Good afternoon, my lady. If I may just go through my skeleton submissions.
Yes.
I will start with, this is an appeal by the Crown against the Guided Magistrate's decision on the 14th of January 2020, wherein he made a finding that the respondent had no case to answer in respects of counts 1 and 2 on information 16 CR 00318. Just a brief background, my lady, if I may. The Crown's case is essentially that on the evening of the 26th of May, 2016, the complainant Benita Alexavier parked and locked her motorcycle, a white Honda Spacey 110cc motorcycle, registration number BW951, outside of her residence. On the morning of Friday, the 27th of May, the complainant was about to leave for work, and this is where she found that her bike had been taken without her consent, and the police were subsequently called. Approximately 2:45 p.m. on Wednesday,
Sorry, give me the date of the theft of the bike.
So the 27, between the 26th and the 27th, my lady.
26 and 27.
2016, yes. The complainant locked the bike on the 26th.
The full date, please.
Pardon?
The full date between the 26th and 27th of
May 2016.
Thank you. Yes.
Sorry. And then on approximately 2:45 on Wednesday, so we have two complainants. The second complainant is Mr. Franklin Fergo, and this was where he was riding his bike. He was riding his Yamaha Mio 125 east along North Shore, and was at this time in a cycle, which was behind him, right beside the complainant, reached across his chest and grabbed the pendant to the gold chain.
This is on the 1st of June, 2016.
Yes, my lady, at approximately 2:45 p.m. So a mere 5 days after the motorcycle was stolen, reported to have been stolen.
Mm-hmm.
The rider gave a quick tug to pull the chain from around the complainant's neck, and this caused the chain's clasp to break. The rider looked behind and sped away east. However, the rider who snatched the penalty and turned up Trinity Church, but slowly made a U-turn, and was at this time that Mr. Fergo pursued the rider and noticed the registration of the rider's scooter type cycle to be the registration number of the stolen motorcycle BW951.
Yes.
The suspect then made good his escape along Trinity Road, and thereafter the matter was reported to the police. That's on page 57 of the record, my lady. That's the evidence. And that would be the statement of the complainant, Mr. Franklin Fergo.
Thank you.
You're welcome.
Yes.
And then about 3:45 p.m. that same day, on the 1st of June 2016, uniformed police officers were on mobile patrol along Dundonald Street in the city. They had been previously made aware of Mr. Fergo's complaint to the police, and they observed BW951 being driven by someone whose description fit that of Mr. Fergo's.
So Mr. Fogo's statement was read into evidence?
Yes, my lady.
Okay. Yes.
And then, so as a result of the information received and the fact that the defendant on the bike matched description of that of Mr. Fergo, they gave chase to BW951 around the city. However, the pursuit ended on Carbon Avenue when the rider lost control of the and collided with a staircase railing on the near side of the road. The rider then jumped to his feet and ran off in a westerly direction through the yard of an adjacent residence. A uniformed police stayed with the stolen motorcycle and its contents until additional police personnel, and I'm now on paragraph 6, my lady, of my submissions. Personnel came to assist and secure the motorcycle helmet and the contents from the motorcycle which the rider left. The rider of the cycle fled the scene.
All right, 1 moment. Let me just get your submissions out, please.
Okay.
You said you're on paragraph 6 of your submissions?
Page 2, that's correct, my lady.
Okay, yes.
Just finishing paragraph 6, where the rider of the cycle fled the scene and was not located following the searches of the area. BW951 and the helmet seized at the scene were subsequently forensically examined. The mirror and side panel of BW951 has substantial fingerprint evidence belonging to the respondent. And my lady, I will take you, I will get there in a minute as far as the fingerprint evidence, because we have a specialist, Monique Hill, who provided an analysis. There was also substantial fingerprint evidence belonging to the respondent on the helmet. Based on this information, the respondent was subsequently arrested and fresh prints were taken, and he was subsequently charged. If I may now move on to paragraph 10, the Crown's case is that given the description of the rider and the bike registration details given by Mr. Fergo to the police, and given that it was the bike being ridden by a rider wearing the clothes described by Mr. Fergo a mere hour later, we submit there exists strong circumstantial evidence that the rider of the bike who fled the scene of the collision was that same person who robbed Mr. Fergo of his pendant. Further, the rider left his fingerprints at the scene, and that the rider is ultimately the respondent who was arrested.
Okay, take me to the description given by Mr. Fogo in relation to the rider's clothing.
Page 57 of the packet.
I can see where I think it's page 57, mid-paragraph. I can only describe the rider as a black male wearing light t-shirt and dark pants.
Yes, my lady.
Okay, is that the full description given by him?
Yes, my lady.
Okay. Yes, thank you.
If I could go on, we submit, my lady, that the fingerprints match those left at the scene, and we also submit that the behavior of the respondent.
I'm struggling to hear you, Ms. Tweed. I'm sorry.
Can you hear me now?
Yes, thank you.
My apologies.
That's fine.
We submit the respondent giving chase and fleeing the scene is evidence of a consciousness of guilt, and therefore it is sufficient evidence upon which the Crown's case that the respondent is made, and there is a case for the respondent to answer. So essentially, my lady, the ground of appeal that we are relying on is simply that the learned magistrate erred in law when he found in relation to count one that there was
no evidence on count one.
No evidence in count one. And then in relation to count two, that the evidence was so weak and tenuous that a trial fact properly directed on the law and facts could not convict the defendant. If my lady is with the learned magistrate in that there is no evidence regarding count one, we still submit that there is sufficient evidence in count two, my lady. And the crux of the ground's case is that of the fingerprint evidence. If I can take you, well, if I could just go further for my submissions because I address these issues. We say that while there is no direct evidence that the defendant removed the BW 951 without the complainant's authority, there is strong circumstantial evidence which infers that the respondent must account for having possession of the motorbike a mere 5 days after it was reported stolen.
So why don't we deal with it separately in terms of the counts? So okay. Count one, you obviously say that the magistrate erred in finding that there was no evidence upon which a jury could convict.
Yes, my lady.
And the evidence that you would argue the magistrate ought to have considered to be sufficient would be the fingerprint evidence that was found on the bike?
Yes, my lady. And the case taken together in totality, the circumstantial evidence, everything ties in together. So from the bike being stolen to the defendant being chased, and then the defendant's fingerprints being found on the motorcycle, we submit that the evidence together is one where there is sufficient evidence that a trial fact properly directed could convict the defendant.
So how would you tie that together if we just focus on count one for a moment?
Okay.
So on a date in May, what was that, 26th or 7th of May, you have on the information the 26th of May.
Yes.
So that's a date that the Crown sought to prove if you look at count one.
Yes, my lady.
So on the 26th of May, the complainant in respect of count one reports that her bike was stolen. Was that when she reported on the 26th of May?
The 27th, my lady. So
oh, I see. She reported it the day afterwards. Okay.
The morning when she intended to go to work, that's when she found her bike was taken without its consent.
I see.
Her consent.
And then the evidence that you would rely on is that Mr. Fogo, when he was robbed on the 1st of June, observed that this person had on dark clothing. Yes. and was riding BW 951, yes. which was the same registration plate as Ms. How do you pronounce her last name? The complainant for the first.
Venetia, VENESHA, T-I-A.
That's the first name. What's her surname?
No, that is her surname.
Is that the surname?
Yes, her first name is Alex. I'm sorry, my apologies. Her first name is Benita Alexavia. So it is Veneta, last name Alexiva.
How are you pronouncing the surname? Okay, not much turns on it. Complainant in relation to count 1. And later on in the day, on the 1st of June, the police give chase to a rider on BW 951 who is wearing dark clothing. Where does the police describe the clothing of the person that was on the bike on the 1st of June? Where can I find that evidence? Mm-hmm.
Forest Evans.
You look in the statement of the Forest Evans, it should
Yes,
be.
The Forest Evidence.
So pages 58 to 59 of the record?
Yes, my lady. And if I can take you to line 6 of page 58.
Yes.
Wherein DeForest Evans states, I observed that the rider was male, brown-skinned in complexion, approximately 5'10" in height. He was wearing a white t-shirt with dark-colored pants and dark-colored footwear. And then it just says the rider was of a slim, medium build.
Sorry, is this a statement that starts at line 3 around 3:45 p.m.?
Yes, my lady, page 58.
And what line were you reading from?
26.
Oh, 26. Sorry, I thought
Yes.
that was 56.
I'm sorry.
I see it. Yes, okay, I see it. So white t-shirt with dark colored pants and dark colored footwear. Did Mr. Fogo describe the rider of BW 951 by height?
No, my lady.
Okay. So really, the description is confined to
Clothing.
let me see Mr. Fogo's description again. One moment.
Page 57.
Thank you.
Simply the clothing.
A light t-shirt and dark pants, which you would say is consistent with Mr. Evans or PC Evans' evidence of a white t-shirt and dark colored pants.
Yes, that's correct, my lady.
Okay. One being described, and then of course, on one description, he was brown skinned in complexion, and Mr. Fogo describes this person as being a black male.
Correct.
Okay. Yes.
Yes, my lady. So that's basically the crux of count 1, and we submit that, like I said, the circumstantial evidence, in that the respondent has to account for.
You would describe that as evidence sufficient to pass the second limb of the Galbraith test?
I believe that together with all of the evidence as a whole, my lady.
Well, I mean, we're looking at the evidence as a whole, but you now have to identify what all the pieces are.
Yes.
So let me just make sure I haven't missed out any of the points that you would string together. So you've obviously spoken about the registration plate,
Yes.
the comparable description of clothing, being a white t-shirt and dark pants. It's not a very detailed description in terms of clothing. One says a light t-shirt and dark pants, the other says a white t-shirt, but you would obviously draw some parity between those descriptions in any event. And then the fingerprint evidence.
Yes. And then in respect of the fingerprint evidence, we rely on the report of Ms. Minikio, and that is page 64 of the record.
64?
Yes.
Okay. Yes. So that's Miss Monique Hill Lee's statement. Was this read into evidence, or did she
She gave live evidence.
gave live evidence? Okay. Was she cross-examined?
Yes.
Okay.
So essentially, my lady, she looked at the fingerprints that were taken from the respondent on the 29th of July, 2016, when he was arrested.
Yes.
Yes, and Miss Hill lifted the fingerprints, and she told us explicitly in court that there were no two same people with the same fingerprints.
Yes.
She indicated that rich characteristics may be similar, however, the placement of rich characteristics differ from person to person. Now, if we can go to page 64 of her comparison chart, my lady,
Yes.
you will see that the fingerprints of the left thumb and left palm vena area, there were 20 plus ridge characteristics on the left thumb, and then left palm 16 plus ridge characteristics. And that was on the right mirror. On the side panel, my lady, of the motorcycle BW951, we have the left ring finger, which has 9 ridge characteristics. The upper front panel, there was insufficient detail. On the helmet.
Remind me, it's been a while since I looked at fingerprint evidence, but she reports when it's 8 or above. Is that right?
That's correct, my lady. However, in recent law, there is, I don't have it before me, but it's based on the judge's discretion as to the amount that is relevant. But it was a minimum of 8 previously.
Okay. But in either case, 16 and 20 ridge characteristics are very high numbers that one would expect a court to accept as strong fingerprint evidence. Is that correct?
Yes, my lady.
Okay.
And then on the helmet, essentially, his fingerprints were found on the right mirror, the side panel, as I have just indicated. And
on the helmet?
Yes.
And that's a helmet that was left and abandoned at the scene when the police gave chase?
Yes, my lady.
Okay.
So we submit that the nature of the prints found suggests that it is our submission that he was positioned on the motorcycle as a rider while wearing the helmet. And the specific position of the prints in conjunction with the helmet are sufficient to support a reasonable inference that he was the rider.
I mean, it supports a reasonable inference, doesn't it, that he was riding the bike? How does it support a reasonable inference that he stole the bike?
Or that he had knowledge that the bike was stolen, my lady.
Sorry?
Or it can be that he had knowledge that the bike was stolen.
No, but he's charged. One minute.
Yes, with stealing. Yes.
Because the test, I mean, this is an appeal against the no case ruling. So the test is whether or not there was evidence upon which a jury could properly directly convict. So looking at count 1, the charge is that he took this bike without the consent of the lawful owner, contrary to section 342 of the criminal code. You've addressed me on evidence of him quite possibly, I think by reasonable inference on your argument at least, being in possession of the bike. How do we get to him having stolen the bike some 4 days prior in terms of a test of sufficiency?
That is the bulk of the evidence, my lady, and if the court is not with me, then.
Well, no, I'm asking you. I'm certainly not debating it with you. I just I'm inviting you to address me as to how I should look at it.
My lady, if I may,
Yes.
Even though it was 5 days after, we may consider the doctrine of recent possession.
Mm.
Given that there was no other fingerprints the Crown submits on the bike, it may be inferred that no one.
Wait, one moment, Ms. Smith. I didn't see that from the statement, so let me just understand that on the evidence. What page were we looking at? 57, I think it was, or somewhere thereabouts. What page is the fingerprint evidence?
64.
64?
Ms. Monique's comparison chart,
Yes.
page
Okay,
60.
thank you. Okay, just so where does Ms. Monique Hilley report that no other fingerprints?
Well, my lady, this is just it. She doesn't say that she lifted any other prints.
Oh, I see.
Right. So she doesn't explicitly say that there were no other fingerprints captured, but these reports will often, more often than not, actually say that they lifted a print but couldn't attribute it to that of the defendant in this case. This report does not state that. This report.
But then if it doesn't state that, is it proper for you to know, translate that into being evidence that there were no other prints on the phone and the bike?
But if there were other prints, these reports usually do.
You're inviting me to speculate.
Okay, notwithstanding that point,
Mm-hmm.
My lady, because there are no other fingerprints, that the only fingerprints that Ms. Lee speaks to are those of the defendant. If someone else had taken that bike without the owner's consent, the Crown would submit that there would be other prints belonging to another on perhaps the helmet and on the bike as well.
Can I be taken to the notes of the evidence of Ms. Monique Hilley, please? I'm looking at her statement, but you said she gave live evidence, so can we just look at that evidence for a moment, please? And a page reference would be helpful.
Yes, Ms. Tweed, the evidence of Ms. Hill in the record?
Yes, I have Monique Hill, page 23.
23?
Yes, but I don't know if my data is going to be able to put.
No, I don't want to read any handwritten notes. It must be a type.
It's the typed version.
Page 29 of the record.
Yes, ma'am. Sorry.
So there were 4 lifts that were marked and labeled by Officer Thompson.
Officer Thompson was the officer at the scene,
Mhm.
who stayed with the bike and the helmet and the fingerprints. And his evidence is on page 65, if my lady needs to.
Well, no, it's fine. I'm not as concerned about, well, let's look at it just for the sake of completion, because see what he says.
Bottom of the page, my lady.
Sorry,
Bottom of the page.
thank you. I'm looking at the bottom of the page of 65, page 65. Several finger marks were developed, which I exhibited as, oh, look at that. At this time, I made a fingerprint exam of motorcycle BW951, and as a result, several finger marks were developed, which I exhibited as, and then he talks about all these different areas of the cycle. So PT 1, 2, 3. And then the same for the helmet. So he found 3 lifts.
Yes.
Okay. And then Ms. Hill looked at all 3 lifts, presumably, yes?
Yes, my lady. And that's when she completed the comparison chart.
And her evidence was consistent with her fingerprint chart on page 64. Is
Yes,
that correct?
yes, my lady.
And 2 out of the 3 lifts in respect of the helmet and the cycle read as insufficient detail.
Yes, my lady.
So I really can't make any inferences from that at all. Is that correct?
That's correct, my lady. Your meetings.
Okay. All right. I think I have a good understanding of the fingerprint evidence. You can continue.
Thank you, my lady. If I can, so I finished at paragraph 17, page 3 of the skeleton submissions were in. Ridge characteristics may be similar, however, the placement of ridge characteristics differ from person to person. And we submit that the overwhelming conclusion is that Shayne James was the rider of BW951 on the day when Mr. Figger was robbed. We already touched upon this evidence wherein Mr. Figger described the clothing of the rider, like shirt and dark pants, and then a mere hour later, Constable Evans observes the same bike, same registration number as described by Mr. Figger, being ridden by a black male. And he said light shirt and dark pants, but we submitted quite similar clothes.
Now, Ms. Smith mentioned this doctrine of recent possession. Do you want to address me on that? Or Ms. Smith may wish to address me.
Okay. I was actually addressing or making that doctrine applicable possibly to count 1, in that the possession of the bike happened a mere 5 days. The bike was found in possession, bearing the fingerprints of the of the respondent a mere 5 days after it was reported as being taken. And we know that on the case law of recent possession, the definition of recent is basically a matter of circumstance, of fact and degree, depending on the circumstances of the case. Given that evidence and given the multitude of characteristics or fingerprints which were found on the bike and on the helmet, certainly the defendant should have been made to account for his having been in possession of the motorcycle,
Right.
bearing the same, obviously the same registration number 5 days after it was reported stolen. In a lot of the case law, depending on a matter of the circumstances of the fact and degree, 9 months would be too long. We're saying in the context of this case, 5 days is in fact recent. Mm-hmm. And that the defendant did have a case to answer in reference to count one, because we say that his entire behavior, having been on this bike, his fingerprints all over it, and then trying to escape the police, dropping the bike, getting rid of the helmet, and subsequently running, is consistent with someone knowing that he has done something criminal. And we say that is having the bike and having just robbed an hour later Mr. Fogo. We say that there's a strong, the evidence is consistent with the defendant being the rider of the bike, because there's not much difference, and we say it's quite alike in description between the description of Franklin Fogo and DeForest Evans, being the description of the clothing. We also say that if where that those fingerprints were found on the bike were consistent with someone being a rider of the bike, and if in fact, if it wasn't the defendant, well, where would we would want to have the rider and robber's fingerprints all over the bike as well, and all over the helmet. Like we said in the submissions, if the defendant wasn't the rider and it wasn't the robber, well, he must be the unluckiest person in the world, because who if he wasn't the rider, where's the other person's fingerprints on the helmet and all over the bike? He should have been made to account for that. He had a case to answer. And the inference is strong that he was the rider.
Okay. Well, I understand your points on the recent possession. I didn't want to tempt you into a submission on it if Ms. Tweed is going to make similar submissions. But I have noted your points in respect of recent possession.
Mm. Thank you.
All right. Do you now, do you want to now focus a little bit more on count two, or?
Well, my lady, that is the crux of the Crohn's case. We submit that the crux of our case is that there is fingerprint evidence. We submit that the evidence is quite overwhelming. And like we said, most importantly, the nature of the prints found on the bike, the places where they were found suggest that he was positioned when he made that on the motorcycle as a rider while wearing a helmet.
Let's see.
And we also submit that the number of ridge characteristics that were found were not challenged in court by my learned friend.
Yes.
And therefore, in the circumstances, we say that the Crown has discharged the burden under the principles of Gilbreth, and that there is a case for the respondent to answer. May I just confirm that you have the case of Virginia versus Sakiri? TS.
All right, Ms. Tweed, I'm going to ask if you can just speak a little. I don't know if there is an echo or
Can you hear me now?
background. Yes, thank you. Maybe do you have an air conditioning sound in the background?
My apologies.
Okay, that's fine. Well, I mean, you don't have to turn it off. You just keep your voice elevated. It's fine.
The case of.
All right, so which case are you referring to now?
The case of Sekiri, it's Tsekiri. My apologies. I believe it was sent on the last occasion.
I have 3 cases that appear to have been submitted under your
Galbraith?
arguments. Galbraith is the first one.
Yes.
And then there's a Court of Appeal case from Jamaica as a second. And then there's our own Court of Appeal decision in the case of Tanae, Parent Chief Leader.
Ms. Smith, I believe it was sent to Ms. O'Connor, was it?
When was it sent?
On the last occasion, my lady. It was sent via email.
Okay, well, let me see. Maybe it's a more recent. Oh, I see one. Yes. That's 2017 One Weekly Law Reports.
Yes.
Okay. Yes, I have it. Thank you.
So essentially, my lady, we just wanted to, the Crown intends to rely on this case as it is similar. If I can take you to paragraph C, where the fact that DNA was when an article left at the scene of a crime may be sufficient without more to raise a case to answer where the match probability to the defendant is or similar. And then if I can move to paragraph.
Is what? Sorry.
Pardon?
The match.
Was similar. It says is similar. Paragraph 14.
Maybe Ms. Christopher is asking the same question that's in my mind. What is that writing between is and or?
I cannot confirm, my lady.
Okay.
But I take it to state that the defendant is or similar.
All right. Anyway, go on.
1.1 billion, to be clear.
Or similar. Thank you, Ms. Christopher.
No problem.
Ms. Christopher says it reached 1.1 billion.
Yes, or similar.
Mm-hmm.
And then paragraph E, it was held that there was no evidential or legal principle which prevented a case solely dependent on the presence of the defendant's DNA profile on an article left at the scene of a crime being considered by the jury, that in the circumstances there had been a case for the defendant to answer, since his had been the major DNA profile on the handle of the car door used by the offender in the course of the robbery, and that since at the close of the prosecution case, there had been no explanation for the fact. The jury had been entitled to reject the defendant's invitation to conclude that the prosecution had failed to prove its case, partly because they could rely on the defendant's failure to give evidence, and they had no explanation of the presence of the defendant's DNA profile.
What was the charge concerned? This was robbery as well, right?
Yes, my lady. And we submit that in our case, fingerprint evidence, we say that it has the same effect. DNA is as distinct as fingerprint evidence. And as we have said, this is the main crux of the Crohn's case, the fingerprint evidence. If I can take you to page or paragraph 5. Written, this was at the trial, at the conclusion of the prosecution's case.
Sorry, just let me, were you taking me in this case?
To paragraph 5, my lady, to take you to the trial. Okay. But first, I can actually take you to paragraph 3.
Yes, that's where I was just about.
Scientific evidence.
I think you might have to start at paragraph 2. Because
I read paragraph 2, thank you.
Because
it gave me some context. Yeah, I did just have a quick read of it. Thank you. Okay, yes.
So essentially, my lady, this deals, as you are aware, with DNA evidence, and we submit that is similar to that of fingerprint evidence. And it was at the conclusion on paragraph D5, the prosecution case, a submission was made to the trial judge that he should withdraw the case from the jury on the basis that no reasonable jury properly directed could convict. The same issue here could convict on the available evidence. The trial judge rejected that submission. In his ruling, he said that where the finding of DNA attributable to a defendant at the scene of a crime was the sole evidence against the defendant, it was necessary to examine the circumstances of the particular case. Whether such evidence was sufficient to justify consideration by a jury would be dependent on the particular facts of that case. And he concluded that the totality of the evidence called by the prosecution was sufficient to go before the jury. And essentially, my lady, that is our argument in a nutshell. We submit that the totality of the facts of this case were sufficient to make it pass the case submissions, my lady.
Well, then you really have to look at it almost on a fact by fact basis. I'm just looking at paragraph 4 of this case, where part of the evidence was an inference that was drawn from the defendant's response in a police interview, where the police officer mistakenly questioned him about a watch, and he said, "What watch?" When the police officer meant to say a necklace. And presumably the inference drawn from that was that the defendant seemed surprised to hear about any mention of a watch when the stolen property was in fact a necklace. So that would just be an example of, obviously, looking at the evidence in its totality, as you would put it. It really becomes a fact by fact exercise. And what I can take from Security is that you really do have to look at the evidence as a whole.
Yes, my lady, I agree with my lady. We submit and I don't want to reiterate it and sound like a broken record, but we do submit that the evidence of this case taken as a whole provides sufficient evidence. It's sufficient.
Was also Steeman found. Is that a different case they're citing? Oh, I see. I think you're citing I'm looking at paragraph 6. So it's going to different cases where they look at the supporting evidence. Or it may be DNA evidence. I think in that particular case, it was semen found on the clothing. Other cases are high DNA matches. But I don't imagine there's going to be much resistance to the principle that you have to look at the evidence and see how the evidence supports whatever the forensic evidence is. Okay. You had other cases. Do you want to speak about any of the other cases that you?
Not at this time, my lady. The basis of this
relying on the other cases that you
cases. Pardon?
Are you relying on the other cases that you submitted?
Not at this time. Essentially, that was the main case that we intended to rely on.
So I can ignore the other authorities that you sent?
Well, the purpose of the Galbraith obviously was in support of our case that we have a case to answer.
No, not Galbraith, but
and then
the Jamaican Court of Appeal case and the Tanae Parent-Chief Leader.
The Court of Appeal case, my lady, was essentially to provide guidance in respect of circumstantial evidence, specifically paragraph 45 of that case, where it just gives a brief synopsis that what circumstantial evidence consists of, just to give my lady some assistance. I know you don't need guidance, but just some assistance in relation to the circumstantial evidence. And then in respect of Ms. Leader's case, the importance of that case, my lady,
That was a case where the Court of Appeal found that the trial judge erred in citing the test for no case submission. It was a Section 31 application.
Yes.
And I think the judge dismissed the case on Section 31. Jurisdictional points arose, but the Court of Appeal looked at the merits of the ruling in any event, right?
Yes, my lady.
And emphasized that the test really, when they substituted the court's inherent jurisdiction to apply the principles under Galbraith,
Yes,
the emphasis was really about what a jury could convict on, as opposed to what the Crown had proven.
yes, my lady. Essentially.
So is that your purpose for citing the case?
Yes, my lady.
Of course, it's to be remembered that in that case, there were statutory presumptions in terms of that case involved, it arose out of the police executing a search warrant and finding firearms in some suitcases, right?
Yes, my lady.
So you don't rely on it for the facts of the case, but just simply for the remarks that the Court of Appeal made in relation to how no case rulings should be approached?
Yes, my lady. That's simply the basis of that.
All right.
Thank you, my lady.
Anything further?
Not at this time.
Thank you very much, Ms. Tweed. Ms. Christopher?
Yes, okay. I think I'm going to be a bit.
Ms. Christopher, I'm going to ask you to keep your voice up. Unfortunately, it may very well be my own computer device, although I've done recent hearings and not had such an issue with the audio, but
Right,
just to
so
keep your voice elevated.
I had a microphone, but it stopped working.
Okay,
So I'll try to keep my voice up.
thank you.
I think we're going to start with security because I think my learned friend's appeal is premised on a few false assumptions. First of all, there's no analogy between DNA and fingerprint evidence.
Mhm.
So if you look at the evidence of Monique Hill,
Yes.
I think indeed she was confusing to some extent DNA evidence and fingerprint evidence when she says that no two fingerprints are alike. Because the reality is that there is no statistical work that's really been done in that particular area. In the same way that, of course, with respect to DNA evidence.
You're asking me to take notice of this?
Yes, my lady. So if you look at page 29, of the record and her cross-examination, it is correct, she said no two different individuals have same identification marks. It has never been found. I think she's confusing DNA because she actually goes on to say, cannot say what number of persons in population have the same number of rich characteristics in the same place from the defendant. So that can't even conceivably stand with the previous paragraph. And then it goes on to say the higher the number, the greater unlikeliness of similarity. You got to remember when you're dealing with fingerprint evidence that a person who's doing the examination is provided with the lifts and a number of known prints. And so, that analogy doesn't take us anywhere. But in any event, there's no suggestion, of course, that we're talking about the same numbers in the DNA case of probability or the like that's being referred to with DNA evidence, where it says, where the numbers are 1.1 billion or similar, then
You didn't call any expert evidence.
No, because
Hmm.
it's obvious that it's fingerprint evidence, not DNA evidence. This is fingerprint evidence. I did not. I think when she said she cannot say what number of persons have the same number of ridge characteristics and similar placement as the defendant, that really ends it. I mean, there's a reason why fingerprint doesn't have the same favor it used to.
We're talking about a no case submission ruling. Is it not,
Right.
was it not open to the court, um, looking at what the evidence was in terms of rich characteristics as high as 16 and 20, to find that to at least be impressed by the fingerprint evidence, enough for that to pass the no case threshold?
We say no, um, but it's in the context of this case in particular, no.
Mhm.
So if you look at, but let's assume for 1 second, right, that these principles apply to fingerprint evidence. Notwithstanding, where the match probability is 1.1 billion or similar. Um, the facts of the case are important. If you look at paragraph 2, at
Mhm.
about 10:45, a woman named Denise Carr came out of the tube station.
Paragraph 2 of what? What am I looking at? Your skeleton?
No, this is of Sikiri.
Oh, we're still in security. Okay,
Yeah, I
yes.
say let's assume that you could treat it in a similar way,
Right.
right? 10:45, she had come out of Wimbledon Park tube station to her car, parked close to the street, intending to drive home, got in the driver's seat to prepare to drive away, and effectively she was attacked, and the guy was seen handling the door handle, and then so she screamed for help. The person had run, and the swabs were taken to the car. So it's not like a vehicle like a bike that we have in this instance, or a car which had moved from point A to point B. In this case, the car was a static object. So that's one big difference, which you will understand when we go to my authorities on movable objects and fingerprints. In
Mhm.
this instance, it was static, not movable. So in that case, the match probability was 1.1 billion. The paragraph 5, it is correct. Paragraph 5 says if you look at about 7 lines down, it says it's necessary to examine the circumstances of the particular case. But if you look at the general principle, uh, the general principle is basically that you cannot, in every case, automatically exclude DNA evidence. Um, and so therefore, it doesn't really, I think, take us very far in this context. So going to the what is described as the legal principles,
Mhm.
if you look at about line 5 of paragraph 6, the conclusion of the court was that the authorities established that where it was clear the DNA had been directly deposited in the course of the commission of a crime by the offender, and in this instance of this Sakari case, it certainly was because, the car, they, the attackers, there's the car, the attackers came, touched, and ran, and, the people were there. It is very high to say that the um, DNA had been directly deposited in the course of the commission of a crime by the offender. And then it goes on to say a very high DNA match. So again, you see very high DNA match, not fingerprints, we say, that the defendant will be sufficient without more to give rise to a case for the defendant to answer. If you look at paragraph 9, it was put in that case on behalf of the prosecution that this was a case in which there was other evidence which tended to show that the defendant was the robber independent of the DNA evidence. The robber's general description matched that of the defendant. We'll get to descriptions here. His response on arrest showed that he knew what had been stolen in the robbery. The defendant had lodged a defense statement in which he said that he was in the general vicinity of the robbery when it occurred, and the judge being entitled to take that into account at the close of the prosecution case. So if we go over to page 2884 and paragraph 14,
Yes.
the facts of this appeal require us to determine the position when the defendant's DNA profile at the scene is the only evidence. In our view, the fact that the DNA was on an article left at the scene of a crime can be sufficient without more to raise a case to answer with the match probability is 1.1 billion or similar. Whether it will, because it's not automatic, basically this saying it's conceivable that it can. Whether it will depends on the facts of the particular case. Relevant factors will include the following matters. Then it goes on to cite what the following matters are. In paragraph 15, it kind of relied that I'm not going to go into that because it kind of relied on their abolition of the right to silence and therefore the adverse inferences that can be drawn. If you look at paragraph 16, was the article apparently associated with the offense itself? Here, the DNA profile was found on the door handle, which was used by the offender in the course of committing the offense. There can be no doubt that the offender did touch the article in question. The position could be different if the article was not necessarily so connected with the offense. For example, if it was found on a cigarette stub discarded at the scene of a street robbery. And I simply say in respect of that in this case, there's nothing to suggest that the offender touched the article in question. And I say it because of this, and it kind of arises out of what my learned friend was saying. In this case, we have no evidence that every conceivable lift on the bike was lifted, or that, we have no evidence that every conceivable.
2 out of 3 in respect of the bike and 2 out of 3 in respect of the helmet. Is that fair?
Yes. But we still cannot say, because we didn't hear from Thompson himself, that he lifted every lift there was to lift. But he did give us evidence about having lifted lifts. That's number one.
His statement was read into evidence?
Yes.
Okay.
Number two, we don't know whether the person who robbed was wearing gloves, for example. So, and there's no evidence that he was wearing gloves, and there's no evidence that he wasn't wearing gloves. So to try to draw some inference from the fact that his arguably are the only evidence that we heard about, the only fingerprints that we heard about in court, doesn't take us anywhere.
Tell me something, the property, was that ever retrieved? The gold chain? Was it a gold chain? What was the property that was robbed from Mr. Fogo?
Pendant, I think. Was it pendant?
Right, a pendant. That was never retrieved?
No.
Okay, thank you.
So I can only say that, we can't speak to whether or not his was the only fingerprints because of the evidence that was led. And also, in any event, even if it were the only fingerprints, the fact that we can't speak to whether or not the robber wore gloves or didn't, because it may be quite common for a robber to be wearing some sort of something to mask his print or not. So there's that point. The next point is how readily movable was the article in question? And of course, the article that the fingerprints were on in this case is extremely movable. A DNA profile on a small article of clothing or something such as a cigarette and at the scene of a crime may be of less probative value than was, as is the case here, the same profile on a vehicle. But the key thing about the word vehicle there is that in this instance of this Sakari case, the vehicle was a static object. And when you go to my other cases, they talk about tills versus plastic bags. So in this instance, when you go to the other cases, my client's position or the person's prints found on the object would be more in alliance with somebody's fingerprints that are found on a plastic bag. Is there evidence of some geographical association between the offense and the offender? Because I think in the Sakari case, the gentleman had accepted that he was in the vicinity at the relevant point in time. In this case, it's an Uber geographical point, because there's the geographical point on count 1 and the geographical point on count 2. And then, of course, if you look at paragraph 21, this is not an exhaustive list, and in each case will depend on its own facts. The crucial point is that there's no evidential or legal principle which prevents a case solely dependent on the presence of the defendant's DNA profile on an article left at the scene of a crime being considered by a jury. So in a sense, it's a negative point, but in any event, they're talking about DNA.
Ms. Crickman, let me ask you this. Let's suppose for a moment that I accept or even find that the fingerprint evidence is strong.
Right.
What inferences really would be available to a court to draw from that if the court finds that there is sufficient evidence to draw an inference that the respondent, Mr. James, was in fact in physical contact with the bike and the helmet? In respect of count 2?
None. Absolutely none. That's what there is no inference that the court should be drawing. In fact, the count 2, as far as I'm concerned, is a limb 1 galbraith position. But of course, anything that's a limb 2 is a limb 1. But it's classic limb 1, basically, with respect to the inferences that can be drawn about those fingerprints.
What time, sorry, what's the difference in time between when Mr. Fogo
1 hour.
robbed? Was that 10:45 a.m.? I have it. Oh no, 2:45 p.m.
Versus 3:45 p.m. when you have the Forrest Evans. So it's 1 hour.
It's 1 hour.
It's neither 4 days nor 5 days. It's 6 days.
No, forget count 1. I'm sorry. I'm more concerned. I'm looking at count 2 for a minute.
An hour between the robbery and the seizure of the bike and the helmet.
Thank you.
I said that some time ago.
Sorry?
I said that some time ago. I don't know why my notice pen had to.
Okay. 1. And the robbery was somewhere in Hamilton Parish, and the seizure of the bike was in Hamilton City?
Yes.
Okay.
Yes, my lady.
Thank you. Yes, thank you.
All right, so going to my submissions, which are fairly brief in writing. The bike in question was stolen on the 26th. A week later, 6 days later, Mr. Fogo was robbed of his pendant at 2:45 on the 1st of June, 2016.
Yes.
Bike chase ensued at 3:45 that same day.
Mm-hmm.
There was an issue of continuity with the bike frame, the scene where the bike was left, and the helmet. We had evidence from PC DeForest Evans at pages 27 to 28, but none from the officers who purported to take over from him. PC 708 Swan and Sergeant 1483 Tucker at page 58. So there is a gap. There is no scene continuity apart from anything else. In respect
Was that an issue taken up with the magistrate?
Yes, it was.
And how did he deal with that?
In
terms of continuity.
I don't believe he did. I think he did. Hold on. There's a type version of his. His type notes are pages 46 to 47.
46 to 47. Let's see. Mm-hmm.
Oh, he just mentions it, but he says Ms. Christopher correctly raises issues of continuity as it relates to the bike frame, the scene, and as to when the fingerprints were placed on the bike.
Oh, I see it. Thank you.
We don't accept that.
Well, a few minutes ago, my learned friend was suggesting that he didn't refer to it.
It wasn't made a big deal of, Ms. Christopher. We were in the same trial. And
It was raised as an issue, is what the magistrate says in his ruling.
Yes,
But I'm not sure really how distracted I want to be by that at this point. Let's see if let's see if I need to deal with that, but let's move on for a moment.
Right. In my humble opinion, that's a bridge you would have to cross if you weren't with me on my other arguments.
Mm-hmm.
You would have to cross that bridge.
Mm-hmm.
So, but I think my other arguments are strong, so we can keep moving. The respondent's fingerprints were found on the helmet of the bike frame. He was arrested on the 29th of July and charged on the 1st of August. So that's now another almost 2 months. A nully was entered on the 10th of January 2018, which was the 14th occasion. The matter was before the court. On the 26th of January 2018, the Crown attempted to reverse that nully. The nully was reversed on the 19th of March 2019, and the case, as presented by the appellant, is a fingerprint-only case. So it was some 9 months after that it was finally found that the respondent had no case to answer, and we're now another almost 11 months dealing with this appeal.
Is this just background information?
Yes.
Okay.
Well, it may be related to my final paragraph.
Okay.
Which is how the court would dispose of it if the court were not with me. The appellant's skeleton, we disputed paragraph 6 of the appellant's skeleton argument. Just locate that. Oh, that's the one with respect to the security of the scene, which they've asserted, but they're not correct. The uniformed officer handed his duty over to other officers. However, we know nothing about what happened during their attendance at the scene. They were in the continuity at the scene, wherein the items later came to be examined as broken. Despite what is said by the appellant at paragraph 23 of their submissions, the evidence of Officer Evans is that he did not remain at the scene, and you have to look at page 28 of the record.
You said 58?
28.
Oh, 28, thank you. Yes.
And that's in conjunction with his statement, which is at page 1 minute. Yeah. I did not collect the contents from the cycle nor remain with them once other officers basically arrived at the scene. So he cannot say what was done with respect to the cycle or the helmet.
I mean, in a case such as fingerprint evidence, how damaging is a defense lack of continuity? If you were to compare it, for example, in a drugs case where continuity is perhaps more important to preserve the integrity of the substance that's in police control, but where you're talking about fingerprints found on various parts of a bike and a helmet, where continuity is an issue. I mean, really, how damaging is that?
I mean, it's just an opportunity for the items to be touched after. So it's
an opportunity for the items to be
touched after.
Yeah, but how would the fingerprints of the respondent get on the articles?
If they were touched after.
Touched by who?
The defendant, presumably.
I see.
The court would define that it was his fingerprints. For what it's worth.
I mean, is there a case from? I mean, was there a case from the respondent that he was induced to touch the articles, or that he touched the articles, or that
No.
somehow, okay.
So anyway, that's my submission. What the court makes of it, I'm not particularly bothered. Like I said, it's not the big point in the case, as far as I'm concerned.
Mhm.
However, we do at paragraph 10 dispute that it should be said that the rider left his fingerprints at the scene, because when they talk about the rider, they're referring to the person, I think.
Paragraph 10 of your submission?
Paragraph 10 of my learned friend submission.
Oh, I see.
It says, if you look about 6 lines down further, that the rider, and in that paragraph, the rider is the person who rubbed Mr. Fogo. Further, the person who rubbed Mr. Fogo left his fingerprints at the scene, is what they're saying, if you read that passage.
Mhm.
And what we're saying here is that paragraph 10, we dispute that the rider left his fingerprints at the scene, because we don't know that the rider left his fingerprints at the scene, and that the rider was the respondent. While it may be said that the behavior of the rider of the cycle in giving chase was evidence of consciousness of guilt, there's no evidence that it was the respondent who gave chase. That's all we're saying there.
Right.
And at paragraph 13 of my learned friend's skeleton argument, which deals with where my learned friend says that forensic evidence analysis should have disclosed fingerprints which belong to another, which is about 4 or 5 lines up from the bottom of paragraph 13. We simply say we dispute that the forensic evidence should have disclosed fingerprints belonging to another.
Sorry, repeat that. I didn't hear it.
We said that we dispute, if you look at paragraph 14 of my submissions, that the forensic evidence should have disclosed fingerprints belonging to another. For reasons already discussed, you may have masked his fingerprints by simply wearing gloves, for example. Paragraph 15, there is no visual identification of the respondent being seen by eyewitnesses on the bike. The witness identifies someone who was 5'10" at page 58 of the record, and I think that would be DeForest Evans. His evidence at page 28 shows that the witness himself was 5'9", making him a good judge of the height of the rider of the bike when you're similar heights, of course. The magistrate could see for himself the height of the respondent, but in any event, there was no evidence that he was the height cited by the witness, or that the Crown are indeed truly relying on visual identification at all. And I'm suggesting to you that there is nothing, I think, that one can say constitutes visual identification that the person who was seen on the bike is our client. The clothes that were being worn were entirely ubiquitous. Everybody has dark pants and white shirts or black clothes, or doesn't really take us anywhere, and it's not like they seize clothing consistent with the description anyway.
I mean, the strongest part of the evidence, as far as the Crown could argue, as I see it right now, is really the time proximity between when Mr. Fogo was robbed and then observed that there was a registration plate which matches the registration plate which the police eventually seized, and that this same bike and this same helmet, which the rider abandoned, had fingerprints on the helmet and the bike, which matched the respondent. That's really, I think, where the Crown would have to lay its emphasis.
Right, but
you would obviously say that that's not sufficient.
Yes, you cannot say when the fingerprints ended up on that bike or that helmet, and there's no reason to think that in the same way that bike and that helmet were used on the day in question, that they would have been used together a few days prior.
Well, if you were to ignore count 1 for a moment and just focus on count 2, therein lies the emphasis that the Crown would place that there was only a 1 hour time span between the robbery and the seizure of the bike, and 2 out of 3 lifts taken from the bike and 2 out of 3 lifts taken from the helmet link it to the respondent.
Well, that, like I said, that you cannot draw any inference because of the window where he could have accessed that bike prior. You cannot draw any inference. This is not, it's not that kind of case.
When you say prior to what?
Between the time that the bike was stolen and well, prior period, but certainly prior to the time that the bike was stolen and the time that the bike was used in the commission of a crime. You can say that he was the one who committed the crime because his fingerprints were on there.
No, I mean, I think that point is pretty forceful in respect to count 1, because count 1 is on a date in May, on the 26th of May, I think it is, that the bike was stolen, and then it was reported stolen on the 27th of May. 4 or 5 days later, whatever the count is, you get up to the 1st of June. So your argument has its greatest force if you're going to say that there was such an opportunity for him to have accessed the bike and not necessarily have been the person to have stolen the bike, if the court accepts that the fingerprint evidence links him to having become in physical contact or operated the bike. I understand your arguments as they would relate to count 1. What I want to hear from you, I think, is what you have to say in relation to the fact that at 2:45 p.m. on the 1st of June, Mr. Fogo sees this registration plate, whatever the registration plate is, BW951. And within an hour of him having been robbed, that bike is seized. And I think, if I understand you correctly, Miss Christopher, you would argue that those fingerprints could have been deposited at any point from going as far back as when the bike was stolen.
Correct.
Okay, all right.
Or 2 days after the bike was stolen, or 3 days after the bike was stolen.
Okay.
And where does that get you? It's the exact same argument.
And then the Crown would obviously argue that, well, if you look at how many lifts were taken from the bike, 3 lifts were taken, and it's pretty impressive on the evidence, is what the Crown would argue, that 2 out of those 3 lifts are
it's not at all
acceptable to the respondent.
It is not at all impressive. The only thing that the closest thing the court can say is that he was in contact with that bike at some time prior to when the lifts were taken, right?
Tell me something, Ms. Christopher. Can I draw an inference? Is it open to was it open to the magistrate? Is it open to me to draw an inference that no one else had been in? Well, no, let me put it differently. Because Ms. Smith has invited me to find that the only fingerprint lifts that were available on that bike relate to the respondent.
I know that argument makes no sense, because if I say that somebody could have been on that bike with gloves, like a perpetrator who is in the habit of snatching or is aware that he is using a stolen bike, may wear gloves, where's that argument take you? It doesn't take you anywhere. And if DeForest Evans said that he could definitively say, right, that the rider's hands had contact with the handlebars of that bike, we would be in a somewhat different position. In the same way that in the Zakiri case, there was an eyewitness who could see that the perpetrator's hand actually came into contact with that door handle, right? Such that prints would be left, or in that case, DNA would be left. In this case, you cannot say, there is nothing to suggest that the rider's hands actually came into contact with those items. So that argument gets you absolutely nowhere.
Can an inference be drawn that the fingerprints that were found on the bike belonged to the rider who had jumped off the bike and ran off when the police were given chase?
Absolutely not. Absolutely not. Absolutely not. And that's kind of what my cases that I use go to, right? So if you look at paragraph 18 of my submissions, there are two cases we allude to in order to deal with the fingerprint evidence.
Yes.
Although we make the observation that the more obvious the point, which I think this case is obvious, the more challenging it is to bring authorities. However, I found these two cases of New Bernard Riley and Slater versus Bennett.
Yes.
They're both Scottish cases as it happens, but that's kind of useful because you don't have all the English adverse inference stuff.
Okay.
Or you might, but not in the same way. But of course, there has to be a little bit of translation in in the other case, I think it is, of some of the phrases they use. All right, so New Bernard Riley and Her Majesty's Advocate. The appellant was, if you look at the case, the appellant was convicted of stealing a car and of an assault and attempted robbery committed within 24 hours of the theft of the car in which the car was used. Of course, we're talking about 6-day window here. However, held that as the nature of the false number plates suggested that they had been in someone's possession for some time before the theft, and that there was nothing to show whether the appellant's fingerprints were put on before or after the theft, the evidence was insufficient and the appeal allowed and convictions quashed. And then if you go over to other page numbers in this case, the page numbers are erased. There is, I think it's page maybe 4, the 4th page of this case. And in his report, Lord Galway stated, you see that?
No, not yet. 1 moment. I don't see page numbers. I'm still in the same case, right?
Yes.
And where am I looking?
Page 4, but the page numbers have.
Oh, I see. I'll count it. 1, 2, 3, 4. And what part of the page?
The middle, it says, in his report, Lord Galway
Yes.
stated, this was a narrow and difficult point, but in the end, the advocate deputy persuaded me that there was sufficient evidence of the case to answer, and I accordingly repelled the submission made by counsel for the appellant and allowed the trial to proceed. Then he says, both the Crown and the counsel for the defense approached the issue on the basis that the charges 3 and 4 were very closely connected and should be taken together. There was undisputed evidence that a blue Ford Escort registration number TPS 972Y was stolen from the village car center, Cumbernauld, on the night of 10th, 11th February 1985. There was also clear evidence that the same car, but bearing false number plates carrying the registration number GSU 823X, was used on the afternoon of 11th February 1985 by the perpetrators of the offense libeled in charge 4. They abandoned the car not far from the scene of the crime, where it was found the same day by police who took it into their custody. The following day, 12th February, prints which were proved to have been made by the appellant were found on the back of the number plate. And if you look at the last page of the case, this appeal is presented upon the proposition that there was insufficient evidence in law to entitle the jury to find the appellant guilty of the 2 charges which, as we have explained, are very closely associated. The only evidence against the appellant is that when the abandoned car was found, a fingerprint of the appellant was found on the back of the false number plate attached to the stolen car. The case for the Crown was, bearing in mind timescales involved in the 2 charges, that the jury were entitled to draw the inference from the presence of that fingerprint on the back of the false plate attached to the stolen car that the appellant had fixed or been party to the fixing of the false plate after the theft. The question for the jury has just been stated, and Mr. Bell has argued that there was no material upon which the jury were entitled to draw any inference of guilt arising against the appellant arising from the presence of the print on the back of the plate. There was nothing to show indeed, and no material from which an inference could be drawn whether that fingerprint was put onto the plate before the theft of the car or after the theft of the car. At any earlier stage in this opinion, it was mentioned that the false plates had been carefully selected. They had come from another car of an identical model. They had accordingly been in possession of someone at some considerable time before the theft, and it is quite conceivable that the fingerprint of the appellant could have been put on the plate at that stage. The difficulty is that there is nothing in this case to show whether the fingerprint was put on before or after the theft of the car. All that the jury could do, having been reminded of the discovery of the fingerprint, was to indulge in speculation. They have speculated against the defendant by drawing an inference which was not permissible from the fingerprint alone, that it must have been put on by the appellant after the car was used when the robbery had been stolen, within a period of 24 hours earlier. It is common ground that apart from the fingerprint, there was simply no other evidence whatever for the jury's consideration, and in those circumstances, we have simply no hesitation in saying that the fingerprint evidence was neutral and that the appeal must be allowed. And I'm going to submit to the court that in this case, the fingerprint evidence is wholly neutral. There is no evidence to say when my client's fingerprints ended up on it that his appeared to be for his and maybe two not ascribed to him, and no others that we're going to assume that there were no others that were seen by the police officer is of no moment in this case. Case of Slater and Bennett. A break-in occurred.
One minute, please.
Yes, ma'am.
Yep.
Case of Slater and Bennett. A break-in occurred at a marketplace in Aberdeen. In one of the units at the market, the panels, which I think means accused, paw prints were found on the bag. There was no evidence as to where the bag was found, nor was there any evidence directed to the bag as being associated with a particular unit at which a break-in had occurred, an item stolen prior to the date of the crime. The panel had been at the market on occasion and had been in premises from which items had been stolen, but denied at the police interview that he had been within the premises at which the plastic bag was found. Members of the public ordinarily had access to the market premises, and it was held, going to the next page, that the mere identification of the panel's palm prints on one of the plastic bags did not fix either the time or the place in which the prints came to be there, nor did the evidence that the plastic bag was found within a unit immediately after the break-in fix those premises as having necessarily been the premises in which the bag had been when the panel's palm prints were placed on it, as the premises were within a market to which members of the public ordinarily had access, and which the panel himself claimed to have visited prior to the break-in. That accordingly, it could not be suggested that there was no possibility of the palm prints having come to be on the plastic bag at some other time, other than that at which the crime was committed, so that the evidence at the conclusion of the Crown case had been insufficient in law to identify the panel as having been the intruder who broke into the units, and hence the thief on the occasion charged, and the appeal was allowed.
I mean, the real point that you make, Ms. Christopher, is that the fingerprint evidence is undated. You cannot know
when the fingerprint
evidence, or when the fingerprints
correct
were left on the articles.
Let's be real. In Bermuda, when bikes are stolen, and we know this from a large number of gang cases that we have, for example, that bikes are left around and helmets for use for people to do all manner of things, to go down the shop, to go to whatever. We know that stolen bikes are a whatever.
Would be what happened in this case.
Sorry, Please,
No.
Ms. Smith, try not to interrupt Ms. Christopher, particularly in these kinds of hearings. It's not as easy to revert as it is in the courtroom.
Yeah, but in any event, I don't know where you can go with this.
I mean, you would say, Ms. Christopher, that recent possession, we're not even concerned with the doctrine of recent possession because you can't prove that the respondent was in possession of the bike in the first place.
I say there is an argument. I say that there is an argument to say that he just touched the bike, for example. There is an argument to say that he rode the bike at some other occasion.
Oh, I see, yes.
There is an argument to say that, like, how are you going to dismiss any of
Let me put the question differently.
Yes.
There's an argument that he was in possession of the bike at some point, but
Yes.
you cannot, there's no inference that can be drawn by the court that he was in recent possession. We really don't know. In fact, all we know is that the bike was stolen on the 26th of May. And at some point, one can infer between the 26th of May and the 1st of June, he may have come into contact with the bike, which is how his fingerprints were deposited on the bike and the helmet. Okay.
Absolutely. I mean, that's really my case. When that is the simple fact that's been apparent from day one. Going back to the case, page 4. The second paragraph that actually starts on page 4, going down about.
Sorry, what document we're looking at? Slater and Bennett
still? Yeah.
Okay. Yep.
Under the paragraph that says counsel for the appellant submitted. And I would say that in this case, there was actually blood staining on this plastic bag, which tended to associate the plastic bag with the situation a bit more nefarious, but no testing was done with respect to the blood that was on there. So in any event, it says, unlike the till, which, you know, if your prints are found on the till, there's a break-in. Unlike the till, the plastic bag was a movable article, the history of which prior to 28th of October 95 was wholly unknown, and it could not necessarily be associated only with the premises at Unit 14. And in this instance, the bike is an entirely movable object.
Yeah.
And like I said, that's why I keep, when we deal with the case of Sakiri, that is the car is a static object. So don't let the fact that they're using the word vehicle in there distract you. So it distracted me when I first saw it, but that was a static car. It was not a movable. It's like a house.
Yeah, because I mean, on the evidence, it's not as if the car had been passed around to different people and whatnot. The car was parked. It was stationed. There was an offense that was committed. The police then came on the scene and examined the car.
Right. Unlike the bike in this instance, and
we don't know about the movements of the bike between the date of the theft and the seizure.
Yes, ma'am. So going to page 5 of that ruling.
Yep.
Counsel pointed out that in each of the cases, the article upon which the accused prints had been found was what she termed movable. Such an article was not like something such as a safe or a till, which could be regarded as having been fixed at all times within particular premises. If identifiable fingerprint or palm print of a person were found upon a fixed item, such as a safe or a till, it was a necessary conclusion that they must have been placed there when the person had been within the premises. But that same conclusion could only be reached in relation to a movable article if there was evidence, such as was present in the case of Hamilton, which fixed the period of time within which the prints of the accused could have come to be on the article, so that the accused could only have handled the article at some time in that period, or the evidence associated with the article only with the particular premises, and there was evidence otherwise that at no time prior to the crime did the accused have access to those premises. So, that I think is pretty persuasive. Go down to the third paragraph on that page, about 6 lines down, we consider that the sheriff misdirected himself as to necessary inferences could be drawn from the finding of the plastic bags and the subsequent forensic examination of them. The mere identification of the appellant's palm prints on one of the plastic bags did not fix either the time or the place at which the prints came to be there, nor did the evidence that the plastic bag was found within Unit 14 immediately after the break-in fix those premises as having necessarily been the premises in which the bag had been when the appellant's palm prints were placed on it. The premises were within a market to which members of the public ordinarily had access and which the appellant himself claimed to have visited prior to the break-in. In those circumstances, it could not be suggested that there was no possibility of the palm prints having come to be on the plastic bag at some time other than that at which the crime was committed. That being so, the evidence at the conclusion of the Crown's case was insufficient to identify the appellant as having been the intruder who broke into the units and hence the thief on the occasion charged. And that appeal was allowed, conviction quashed. So with those authorities, I think that it's pretty clear that the Crown, unless one is going to speculate about what happened between the time that the bike was stolen and this other time, and it doesn't really necessarily go back to when the bike was stolen. It could predate that. But let's use when the bike was stolen as a yardstick, so I don't have to deal with where the bike was, where she says she stored her bike, kept her bike, where she worked. Let's leave that alone and just deal with the big 6 days. The Crown have an impossible problem that would necessarily involve a finder of fact to speculate, to reach a conclusion that my client, because his prints were on the bike, somehow was on the bike, not matching the description given, I say, by the, or no evidence that he matched the description given, certainly because he's 6 foot tall, given by the Forrest Evans. And, so I don't, and even if you say that the person who was riding the bike, and it may be right, I'm not prepared to say that that's not right, that smaller window, that person riding the bike for Fogo was the person chased by the Forrest Evans. So that's effectively what my submissions are. I say lim one Galbraith, but if the court is not with me, and that's on both counts, if the court is not with me, I'm going to invite the court to consider that, notwithstanding a ruling that the court may make, this is not an appropriate case for a mistrial, given for a retrial, given the next history of it, where this client has been charged. Well, first of all,
Given the background as you outlined it in the beginning.
yeah, and you think of that it took about 2 months and then they arrest him. So there's that 2 months that he would be burdened with trying to remember. There's the 2 month blind spot that he would have in any trial to be trying to justify what he did 2 months before at a particular time, because it first came to his attention when he was arrested on the 29th of July. So he has that horrible problem to deal with. Then he's going to court all those many times, the matter being thrown out. So he's thinking, okay, it's at an end. And then 2 weeks later, the Crown is coming back and trying to reverse it. And all these other dates that he's had to come back and forth to court, I think I counted 14 times. I just say that it would be unduly burdensome. We're now 4.5 years after the bike was stolen. 4.5 years. And to use the colloquial, we ain't never going down to this, so we're fighting all the way. So, yeah.
Is the Crown seeking a retrial? Yes, thank you, Ms. Tweed.
Pardon me, my lady?
Are you seeking a retrial?
Yes, my lady.
You said yes?
Yes.
Yes, Ms. Christopher, anything else you wanted to add to your submissions?
Uh,
Wasn't an invitation, it was just for clarification.
there's something I so want to say, but I won't.
Okay,
That's all I have to say.
thank you. I've heard you. Ms. Tweed,
Yes, my lady.
I'm going to give you the opportunity to respond on a point that Ms. Christopher raises in relation to the evidence.
Yes, my lady.
I would usually only want to hear from you on the law, but I do want for you to address the point about the fingerprint evidence and whether or not it was open to the magistrate to draw an inference as to when the fingerprint evidence would have been deposited and how he would have done that.
My lady, it was not open to the magistrate to state exactly when and how.
Sorry?
It wasn't, and it was not open to the magistrate
Mhm.
to speculate when the fingerprints were deposited on the bike. We submitted that it was at the time, my lady, when the respondent attempted to rob Mr. Fogo.
On what basis?
Let me ask the questions, please, Ms. Christopher.
My lady,
Yes.
I'll let you guide
So
it.
you say it was not open to the magistrate to draw any inferences. In fact, it would just be to speculate as to when the fingerprints had been deposited onto the bike and the helmet.
Yes, my lady.
All right.
But
And what, sorry?
no, go ahead. Sorry.
And what do you say in relation to the question as to whether or not an inference was available on the evidence to conclude that the fingerprints that were found on the bike belonged to the rider of the bike on the 1st of June, who had been chased by police?
Yes, my lady. We submit that the inference can be drawn based on where the fingerprints were found on the bike.
So it would seem that because of the location of the fingerprints, one can draw an inference that they had been deposited at the time that the police were chasing the rider.
Between the time that the police were chasing the rider, at the time that the respondent was attempting to rob Mr. Fogo, my lady. If I
How
may,
does that reconcile with your first answer that it was not open to the magistrate to speculate as to when the fingerprints had been deposited?
pardon me, I'm sorry.
So bearing in mind that you've already responded to my question, the first question I asked you was whether or not it was open to the magistrate to draw any inferences as to when the fingerprints have been deposited on the bike or the helmet. And I understood your answer to be that that would call for speculation. So it would seem that your second answer should be consistent with the first answer. And the second question was whether or not it would have been open to the magistrate to draw an inference because of arising from the fingerprint evidence that the rider of the bike during the police chase was the same person whose fingerprints were matched from the lifts on the bike and the helmet.
But the inference was made. I'm sorry, I may have misunderstood your question.
No, that's fine. That's fine. Let me put it differently then, because I do want you to have the opportunity to address me on it. How could the magistrate, let me put it differently, how could the magistrate have come to the conclusion that the rider of the bike during the police chase on the 1st of June was the same person whose fingerprints were seized or found on the bike and the helmet?
There is no direct evidence to confirm that. the court to draw the inference that he was the rider on the day in question. And we also, and like I said, based on the fingerprint evidence product, that's as far as I can go with the evidence.
And just to ensure that you have not misunderstood my questions, to be fair to you, do you accept that those fingerprints that were found on the bike and the helmet could have been placed or could have arisen from physical contact with the bike and helmet at any point from the date that the bike was stolen, or possibly even prior to when the bike was stolen on the 26th of May?
Yes, yes, ma'am.
All right. Well, that certainly answers all my questions for you. I don't know if you wanted to make any comments on the legal principles that Ms. Christopher spoke about in the two cases that she referred to behind her own skeleton argument.
My lady, very briefly, in respect to the Riley case, we submit that it's distinguished on the matter of bar in that the accused's fingerprints in this case, as we have submitted previously, are in areas of a bike consistent with him being the rider of the bike, and that's the crux of our case. On a helmet, on a mirror, and we suggest a mirror. When you're riding a bike, you adjust the mirror so you can see behind you. That's our argument in regards to that case. And then in Bennett, whilst my learned friend has stated that the bike is a single movable object, we argue otherwise. We state that a bike isn't a piece of paper that can be just moved, that is a movable object.
When she says a movable object, I think it's what's meant by that is that from the time that the bike was stolen, as alleged in count one does not know what movements occurred with this bike between the 26th of May and the 1st of June. So the bike was moving from location to location, possibly person to person, we don't know. And I think that's what's meant by the description movable object. She contrasted that to the case that you relied on in Security, where the vehicle in question, i.e. the object in question, was a car that had been parked, the offense had been committed at that location. The police were called and then they came and forensically examined it. So there was no issue as to where the car had been between the crime, the offense that was committed, and the forensic examination which followed thereafter.
I'm going to make further solutions.
Okay, well, anything else you want to add?
My lady, could I just say something?
Yes, Ms. Smith.
Yes, just in reference to Ms. Christopher's points about the reliability of fingerprint evidence.
Mm-hmm.
She tended to attack or tried to attack Mrs. Hill Lee on cross-examination about the reliability of fingerprint evidence. And even in her submissions today, she said that's why fingerprint evidence is not favorable. But yet her brand of cross-examination was basically speculative because she didn't present, and she talked about statistical data, but she didn't present any hardcore facts or evidence. She didn't even bring her own expert to suggest or to rebut the position taken by Mrs. Hill Lee. So to that end, the Crown will submit that she cannot speak to the reliability of fingerprint or the rich characteristics, etc.
I mean, Ms. Smith, the reality is that her primary argument survives, even if I accept that criticism that you make.
Hmm.
It's really, I mean, even if I were to say quite plainly that the fingerprint evidence is strong, I'm not impressed by the points in relation to continuity. Her primary case is that you still cannot draw any inferences, and the prosecutor has conceded on this point. You cannot draw any inferences in relation to when the fingerprints would have been deposited. And so from that, you obviously can't draw any inferences as to whether or not the fingerprints belong to the rider who was being chased by police, or if they belong to someone who had come into contact with the bike prior to the 1st of June, or even prior to when the bike was stolen on the 26th of May. That's really what Ms. Christopher's case is. She'll correct me if I'm wrong, no doubt.
That's certainly the principal point. The other ones are just side points.
But and the Crown's case is that certainly the existence of the fingerprints and in the places and in the number in which they exist, the respondent should have to account for their presence on the bike.
Yeah, that's definitely I think what the Crown has relied on. All right, well, unless there is anything further, I think you know that I like to give written decisions for criminal appeals. For the most part on this, they're not really deserving of a written ruling, but I think this case, like most others, should have a written ruling, and so I will reserve to do that. I have quite a few cases to write judgments for as we are at the end of the year, and we've tried to catch up on a backlog from the cases that were not heard during the court closures earlier this year. So I cannot realistically expect that I will give you a ruling before the end of this month, but I do aim to get one by January.
Okay.
Okay.
Grateful.
All right. So unless anything further arises, you can wait to hear from the registry with a draft copy of a judgment. Okay.
I'm grateful.
Judgment reserved. Thank you.
Yeah.